Hello. As we are all aware, the Supreme Court in India recently has ruled on a landmark decision in the case of Tiger Global. The decision once again had India-Mauritius Tax Treaty at the heart of discussion. And there are multiple facets or multiple aspects that the Supreme Court dwelled into, giving a completely fresh outlook on reading of the India-Mauritius Tax Treaty and its application in the modern times. To discuss the fallouts of this, today I am joined by Feroz, who's the head of tax at IQEQ Mauritius, and me, Rahul Charkha, a partner at Economic Loss Practice. Together, Feroz and I will try to decipher the decision and discuss what it means for investors investing into India from Mauritius. Welcome, Feroz.
Thank you, Rahul. As we know, India-Mauritius Tax Treaty has been under judicial scrutiny in India for over 2 decades. Circular 789 and its applicability remains at the heart of this controversy. We have had the Azadi, Bachao, Andolan, McDowell's, Vodafone, and now Tiger Global. Rahul, can you explain what an investor should make out of this entire maze of litigation? Is a Circular 789 still valid?
Well, that's a good question, Feroz. Well, Circular 789 very much remains valid. However, what the Tiger Global has in fact said is how this Circular 789 needs to be interpreted as the law has evolved since the time the circular was first issued and what it stands or where it stands today. The Supreme Court did go into the 789 circular. After the issuance of Circular 789, there's been a lot of newer provisions which have been included in the Indian domestic law. And in light of that, the 789 position, which said that a tax residency certificate alone would be a valid proof to claim the India-Mauritius Tax Treaty benefit, may not be the best interpretation, and that the tax authorities are well within their rights to go beyond just the tax residency certificate and look at the real substance in Mauritius before granting the India-Mauritius Tax Treaty benefit. Speaking of evolution, Feroz, I believe there has been some evolution of law since 2000 in Mauritius as well, isn't it?
Yes, Rahul. Well, the whole offshore sector in Mauritius, we had in 1992 the MUBA Act, Mauritius Offshore Business Activities Act, and this was replaced in 2001. But I think the major change happened in 2007 when we had the Financial Services Act and central management and control was defined in this act as we have 5 criteria, having 2 local directors, principal bank account in Mauritius, board minutes, board meetings where local directors are involved. We have the accounts being audited in Mauritius, registered office, etc., etc. So the law has evolved in terms to try to bring more substance in Mauritius. But when we go back to Tiger Global, Rahul, Tiger Global seems to be an FDI investment in India. Now, considering that this ruling has been provided in the context of FDI, can we say that the determination of residential status purely based on TRC is still valid for FII and other investment funds?
That's a very pertinent question again, Feroz, because in the course of arguments before the Supreme Court, there was a reference from the revenue side on the language in Circular 789, which does speak about or which has reference of FII and other investment funds. Having said so, I would feel it would be a little aggressive to say that the 789 position that is purely based on TRC is a position valid for FII or other investment funds as well. If you look at the whole construct of the decision as laid down in Tiger Global, it seems that, with the evolution, be it an FDI, an FII, or any other investment fund, there would be a necessity to go beyond the tax residency certificate and prove the real substance of the activities that are carried out from Mauritius in order to avail the India-Mauritius Tax Treaty benefit.
In this ruling, Rahul, we know the court referred to the Mauritius entity as a conduit entity merely intended for treaty benefits. But From what I gathered in Mauritius, the entity had senior employees and premises. They had an office in Mauritius. Decisions were routed through the Mauritius office. The courts talk about place of effective management. We talk about effective management and control. And this Supreme Court judgment allows GAR and domestic law to override treaty benefit, where arrangement lacks commercial substance. But I think the big question here is, what is substance for Mauritius-India Treaty? Is it having employees in Mauritius? Is it having office expenditure in Mauritius? Now we talk about GAR impact assessment. What does this entail?
The whole issue of substance, unfortunately, is not like a litmus paper test. So there are various parameters, and these parameters are not defined. Like, for instance, in the Tiger Global case, the signatory to the bank account being outside of Mauritius was given a lot of emphasis on. What is important is that the substance determination, whether it is by employees or by expenditure or by activity, it does ultimately have to prove the control and management in Mauritius. This is very subjective. The whole question is very subjective and needs a very tailored fact-finding analysis. The GAR provisions as well, in fact, Feroz, do talk about an arrangement being impermissible. Now, whether an arrangement is impermissible is an extremely fact-finding exercise which needs to be evaluated on specific facts. Well, we have certain guidance, but it does ultimately go on to the judgment on how the transaction is arranged and why it is arranged the way it is arranged.
Well, I think, Rahul, it's not just about grandfathered company, but also post-grandfathering. We have companies receiving dividend from India, benefiting from the 5% reduced withholding tax, 7.5% interest rate withholding tax. So I think all this GAR impact assessment doesn't necessarily impact only grandfathered investment, but also all the other companies using treaty benefit. But I think one of the questions I had in mind since I've read this judgment was, is the Indian tax authority now going to scrutinize all Mauritian structures? It seemed to me like, they've got the green light from the Supreme Court. Will they go back to prior disposal? I mean, what is the statute of limitation in India, and where do you see this trend going? Is investors now routing investment through Mauritius going to be concerned that they're going to be scrutinized?
Feroz, the way I look at it is that ultimately, yes, an investment from Mauritius is somewhere going to be eye-catching for the tax authorities. It would raise some sort of a scrutiny flag in there. But whether it means that they would go behind every structure, or whether it would also mean that no investments would flow in or should come in from Mauritius, that's the intent of the tax authorities as well. The premise of the Supreme Court decision and what the tax authorities are also trying to say is that we welcome investments coming in from Mauritius so long as there is enough substance in Mauritius to grant an India-Mauritius Tax Treaty. But if this substance or if this creation in Mauritius is only to avail the tax treaty benefits, you very well articulated the benefits even today that are available in the India-Mauritius Treaty. Well, in that case, the tax authorities are going to scrutinize and wanting to satisfy themselves about the substance in Mauritius.
Thanks, Rahul. I think finally, in light of this judgment, and bear in mind, the protocol to the India-Mauritius double taxation agreement signed on 4th of March 2024 is still pending ratification from both countries. What would you advise our clients having grandfathered investment through Mauritius and also having post-grandfathered investment?
I think the crux of all of this, Feroz, is that the India-Mauritius tax treaty or investments into India through Mauritius are obviously going to be under scrutiny more than what they otherwise would be, and there's no harm in that. We've seen practically, Feroz and I, Feroz, you and me have seen that in the consulting world many a times the substance is there, but it's difficult to prove it because of inadequate documentation being maintained, or many a times decisions are just over phone calls without having adequate trail to those things. I think it's important that for investments made into India, with or without the protocol, being ratified, uh, I think the key is really if you're creating enough evidences of your presence in Mauritius being beyond just a conduit, it should be a good case if for the protocol or any other scrutiny, whether executive or judicial.
Thank you, Rahul.
So thank you, Feroz. And I think the key takeaway from all of this is that it's important for clients to really assess where they stand, be it an FDI investment or an FII investment, and look at ways of claiming tax treaty benefit which are righteous and will fall on the right side of the law in the modern times. Thank you.
Thank you.